Good day everyone, I am Princess Magpatok. I am a law student studying at Father Saturnino Urius University. Now, today we are going to discuss about one of the characteristics of a corporation. As we all know, a corporation is an artificial being created by fiction of law, and it has a separate and distinct personality from the people comprising it. So simply put, its shareholders are not directly responsible of whatever liability that the corporation may incur. But there will always be an exception to the general rule, and that is the doctrine of piercing the corporate veil. So the question now is, when do we disregard a corporation's separate entity or personality and apply the doctrine of piercing the corporate veil? Let's find out. So in the case of RF Sugay Corporation versus Pablo Reyes and Cesar Curata, while painting the building of Pacific Products, suffered burns of various degrees caused by an accident. They then filed for disability and medical expenses against RF Sugay Corporation, Romulo Sugay, the president of RF Sugay Corporation, and the Pacific Products. Now, RF Sugay Corporation contended that the corporation was not the employer of these claimants, but it was Pacific Products, which had an administration and supervision job contract with Romulo Sugay, who, aside from being the president of the corporation, had also a business of himself, distinct and separate from the said corporation. Pacific Products, on the other hand, contended that the claimants were the employees of the corporation and Sugay himself. That as a result of the fire, it incurred loss occasioned by the employment of incompetent men in the painting of its factory by the Sugays. So the issue now in this case is whether or not RF Sugay and Co. is the employer of the claimants and whether or not he is gonna be liable. So the court held in this case that RF Sugay Corporation is liable in accordance with the doctrine of piercing the corporate veil. Under such principle, when the veil of corporate fiction is made as a shield to perpetrate a fraud and or confuse legitimate issues, in this case it was the relation of the employer and employee, the same should be pierced. In this case, there was a faint attempt by the corporation to evade liability by advancing the theory that Romulo P. Sugay, its president, was the one who entered into a contract for painting of the factory of Pacific Products, and making it appear that President Sugay acted as an agent of Pacific Products. And as such, the latter should be made answerable to the compensation due to the claimants. Why RF Sugay Corporation should be held liable. And that is it for the case of RF Sugay versus Pablo Reyes. I hope that you learned from this video, and thank you so much for watching. Goodbye!